going to call the Zoning Board of Appeals meeting for the month of August 22 to order. Prior to the start of the meeting, I would ask if anybody in the room has a phone or electronic device. I would appreciate that either you shut the phone off or you put it on silence. If you need to use the phone, please go out in the corridor to use the phone so it doesn't become a distraction to the board members. The board members hearing the cases tonight is member Stephen Lianis, James Sweeney, alternate Orlando Spinola, alternate Ms. Jamie Hodges, and myself, Chair Kenneth Galligan. Our zoning enforcement officer, building superintendent, and clerk to the zoning board is Mr. James Plouffe. The recording secretary tonight is Monica Fragazzo. Prior to the start of tonight's hearing, we have had one withdrawal, and I will read that case, and this case will not be heard tonight. It will be rescheduled for a future date. That is Petition 2272, the petition of Alex Mallow, 753 Pleasant Street, Brockton, Mass., for a special permit, Article 15, Section 2769, to erect a new sign on the roof of the store, which is not allowed in an R1C zone located at 753 Pleasant Street. That case this evening will not be heard. Prior to the start of tonight's hearing, is there anyone here in the room that would like to withdraw? This would be the time to withdraw if you would like. Okay, there are no withdrawals. Tonight's meeting is being televised, and when your case is called, the petitioner will come up to the podium, give your name to the clerk, make your presentation to the board. Following the conclusion of your presentation, I will ask the board members if anyone has a question about the testimony that was just given. When the board has no more questions, I will close that portion of the hearing and I'll open it up for public discussion. At that point, I'll ask for anyone that wants to speak in favor of the petition. I'll close that out, ask if anyone wants to speak in opposition to the petition, close that out, and then I'll ask if there are any public officials in the room that would like to be heard on the issue. Following that, I will close the public discussion for the hearing. What that means is the public input to the hearing at that point has concluded. I will then open it up for discussion among the board members. This is a time when the board members will deliberate and talk about the testimony that was given and how it relates to zoning in Brockton. You will hear one of the members of the zoning board make a request or a motion to grant. If that is seconded, the clerk will call the roll. It requires, in one case, all 5 yeses, the petition will be granted. If there are 4 yeses and 1 no, the petition will be granted. If the vote is 3-2 or less, the petition will be denied. After the clerk gives me the count, I will make the announcement as to whether or not the petition was granted or denied. Tonight we have 6 cases. As a matter of courtesy to the large audience that we have here tonight and to a public official that has another meeting scheduled, I am going to change the order of tonight's hearing, and the first case that will come before us tonight is the case relative to New Heights. So I have talked to the attorney. The attorney is okay with being the first one on the agenda, and I think everybody that probably has an interest in this case is probably here. So the first case this evening is petition number 2277, the petition of Greater Brockton Sports Complex, LLC, and New Heights Builders of Mass, LLC, to seek to overturn cease and desist orders that appear to be based on a misreading of Section 2789A or a lack of evidence in a C7 zone located at Sprague Street and Claremont Avenue. Please introduce yourself to the board.
My name is Jed Rucho. I represent the petitioner in this matter. Good evening to the chair and to the members of the board. We're here to address two cease and desist orders. One of those orders pertains to a Claremont Street parcel. We believe that particular cease and desist order was issued in error. There is no evidence that we've been made aware of any of the alleged activity going on with regard to that parcel. And I understand that perhaps we'll hear from Commissioner Plouffe further on that cease and desist order, and perhaps that will clarify what the issue is. Secondly, we're here on a cease and desist order regarding the Sprague Street parcels. We ask the board to overturn that cease and desist order because site plan review is not applicable to the site prep work at issue here. This is not just our position. As noted in our papers, Commissioner Plouffe has previously determined that the zoning ordinance is not applicable to earth-moving operations during construction of a use allowed under the ordinance, such as our C7 use for our C7 project. This position follows from the language of the site plan review section of the zoning ordinance. In short, our site prep is not the building and utility work that triggers site plan review. The question then becomes, why did the cease and desist order issue, if that's the case? It could be because of a good-natured concern that the site prep work is not regulated. While that is not a legal reason for Commissioner Plouffe to change his opinion, we do note that the Stormwater Authority has jurisdiction over our site prep work and is reviewing our permit applications for a stormwater permit as well as a land disturbance permit, which are due for a decision by August 23rd. While the issue of traffic does not trigger site plan review, we do hear the concerns about traffic in residential neighborhoods. That's why we have an agreement in place with the city to use our Howard Street gate and would be fully committed to doing so for this site prep work. With that introduction, I'd like to bring up Mark Rukas so you can hear a little more detail from him about what our site prep work entails, and also hear from him on what delaying that work does to the project here. Mark?
Hello. I guess I'm here to tell you that the work that we're doing on the project, we're not digging any foundations, we're not doing any structural underground drainage or anything like that. We're just bringing the property down to grade. The property is riddled with boulders as big as your car, you know, and large rocks, ledge. You know, we pulled out some of the stumps, we removed the trees. We're doing things, preparation work. We're not doing anything like structural work or anything you would need to go in front of the planning board for.
Could you speak to what impact, if any, the delaying your site prep work has on the project?
Well, there's such a huge amount of material that has to be removed from the property to flatten the property that it's going to delay this property, the project big time. And, you know, we geared up for this. We bought a lot of equipment and things to do this project. And, you know, we've had resistance all along. So we're looking to keep working on the project.
Thanks, Mark.
Right.
Is that good?
Yep.
So to expand on what Mr. Rukas was just saying, the site prep work that we're proposing to proceed with would go up to the point of blasting.
Sir, hold on. You cannot be taking pictures in this room without permission from the chair.
Okay. Chair, Chris Helms.
I am the chair.
I'm a reporter with the Enterprise. When I'm at city council meetings, I always do this, so forgive me if it's.
I have to notify everybody in the room that you are here from the Enterprise taking a picture. You done? Okay. Just as a notification, we have an Enterprise photographer who has taken pictures. Thank you.
Thank you, sorry for the interruption.
Proceed.
Sure. So the site prep work that we're talking about here would only go up to the point of blasting. At the time blasting is required, of course a blasting permit would be sought. The work would not even bring the property down to grade. There would still be further work to do here. And I point that out to explain how this really is separate from the building work and the utility work that triggers site plan review. Additionally, while it's not directly relevant to your decision, there is the fact that there is a real economic impact to delaying the start of this site prep work. Like I said, at present, we're on course to resume that work after, assuming all goes well, after an August 23rd decision before the Stormwater Authority. Postponing that work to when a planning board meeting is scheduled, and to my knowledge, no such meeting has yet to be scheduled, would deprive the project of revenue which would be derived from processing the material that was excavated, and that revenue would not be flat profit. No, it would just be enough to pay for the project equipment that has been purchased in anticipation of this project going forward. In sum, we're asking the board to overturn the first cease and desist order that I mentioned, the one pertaining to the Claremont parcel, because there's no evidence of the alleged activity. And again, I expect we'll hear from Commissioner Plouffe on that. We're also asking that the board overturn the Sprague Street cease and desist order because it oversteps jurisdictional boundaries with real consequences for the project. Lastly, if the board is not inclined to overturn the cease and desist order regarding the Sprague Street property, we would ask, at least for the sake of clarity, that the board confirm that that cease and desist order dissolves as of the time any site plan approval is issued, because at that point, the site plan approval would govern. Thank you very much.
Thank you. Board members. All right, just as a clarification, there are two issues here relative to the site. One is parcel 181-053. That is the small parcel, and which street are you referencing that to?
I'm sorry, I'm referring to that one as the Claremont Street parcel. So 53 as Claremont.
So this parcel is separate from the other parcel, which is 181-054 through 181-162, which is the location of the fields.
Yes, sir.
Two separate locations on that same geographical area.
Correct.
Okay. Have you been before the planning board on this location?
We've been through tech review, not an official planning board meeting yet.
So site review, has that been completed, or is that still in the works?
The hearing has yet to be conducted on that matter. We've responded to tech review comments, but that process is yet to be completed. That would be completed through the hearing that I mentioned that is yet to be scheduled. We understand it may happen in September, but there's been no commitment in that regard.
So you're anticipating a hearing on this with them in September?
At the earliest, that's my understanding.
Okay. The work that has been done on parcels 181-054 and 181-162, that has been the clearing of all of the vegetation, the trees?
Not all of the trees, but there has been that type of clearing that has occurred, grubbing, if you will, the vegetation clearing, limited excavation, and that's now at a standstill pursuant to our discussions with the city solicitor's office.
What kind of excavation has been going on that piece of property?
What has happened prior to the standstill? The movement of boulders, the crushing of the boulders, the removal of soil and screening of the soil, things of that nature.
Okay, and the small parcel, 181,053, that is owned separately, which would be New Heights Builders of Mass as opposed to Greater Brockton Sports Complex? That's a separate
Yes, sir.
parcel altogether.
Correct. And not even contiguous. There is land in between.
I think there's a paper street or something in between, a proposed street or whatever.
Yeah, at least a paper street, yes.
Yeah. Okay. Board members, any other questions? Everybody's good? We're going to close that portion of the hearing. Is there anyone here that wants to speak in favor?
May I sit?
Sure. Yeah. Seeing none, I'm going to close that portion of the hearing. I'm going to ask for anyone that may want to speak in opposition. Now, prior to, I know there's a large group here. If you remember, a couple of months ago, we had this hearing, and we had a lot of testimony from neighbors and people of interest to this location. So I think the board is well aware of what the concerns are of the neighbors. If there is a spokesperson that could come up to the podium to talk about what is in opposition, it certainly would make the hearing run a lot smoother. And honestly, as chairperson, I hate to hear the same regurgitation of the same problems from a number of different people. So it would be very helpful if somebody representing your group can speak, if you want to, in opposition, and probably hit all of the highlights that may be of concern.
Yes, hi, Mr. Galligan and the members of the board. My name is Lisa Crowley. I live at 250 Howard Street. I'm not a spokesperson per se, but I have been one of the folks leading this charge to get these cease and desist orders because it has been so horrible. We want to get as many of those issues on the record. It exceeds zoning. It's supposed to be a sports complex. It's not. By their own admissions here and in court, it's been an operation, an excavating and boulder crushing, stone crushing business. I understand that they're in a financial bind, but that bind was created by not building the sports complex in 2017 and operating this business instead. If it's a quid pro quo, say no. Say no. Don't get those machines up and running again. He has not kept his word through everything. We can't believe it. It has been such a relief not having those machines going. You can hear them throughout the whole day, all the time. That's been my experience. It's been horrible, not loud, noisy, the dust in my eyes. When he stopped, they started clearing up. They don't hurt anymore. Please do not make a deal. Do not agree. Stand by me, stand by my neighbors, stand by the Claremont Sprague gay building. It's been a horror show. Say no. I understand the situation. Say no for Brockton, for everyone. I'm not a spokesperson. I'm going as quick as I possibly can. The zoning, you can say no. The RFP, you can say no. The new plans are nothing like the old plans. It must be looked at by the planning board. The zoning board as well, maybe at some point. Say no. There's no reason to say yes. Say no. Thank you.
Thank you.
My
I'd
name is
appreciate if you just do not applaud. Let's have some decorum in here. Ma'am,
Excuse me?
go right ahead.
Okay, hi. Is that good?
You're all
All right,
set.
my name is Michelle Henson. I live at 16 Ardsley Street, and I've already sent you an email with my position. However, I'm up here based on something I just heard from the attorney. Now, as someone who lives in Ward 6, and I do understand about the rocky land underneath, and if he actually did have to excavate that and prepare that, I would understand that as a landowner there. However, what does that say about the stuff that he brings in from other towns to process? When did that become okay? Because we don't know what's in that. And that speaks to my concerns about the health of my neighbors, about the powdered stuff that blows into their yards and blows into their windows, and the water that has flowed into some people's basements. So based on what was said tonight, we're led to believe that this is just the processing of land that a lot of us know to be filled with boulders. We get that. But what does that have to do with the stuff trucked in from outside of Brockton? How does that fit into the equation? When was that part of? Thank you.
Thank you.
Good evening, City Council members, City Council Chair, members of the Brockton community. My name is Michael Jenkins. I'm a direct abutter to the property at hand regarding Brockton Sports Complex. I've been subject to all types of noise, environmental hazards, such as the dust, such as rodents infesting my property. I've been quite quiet regarding this matter. I spoke to Mr. Rukas regarding the building of this property. I've reached out to him to speak about the matter again. That hasn't taken place. Neither has Mr. Rukas responded. I have a text message where I reached out to him to prove that. He did not respond. At one time doing this project, I thought it was a good idea for the community. However, the impact on our neighbors is terrible. The dust from this project, the noise from this project is ridiculous. I'm a Commonwealth of Massachusetts employee, and I'm speaking for myself. I have not been notified of anything regarding this matter from the city, Mr. Rukas, or my city council person regarding this matter since December of 2021. My property directly abuts his, more than an acre. He's been very selfish, rude, and disrespectful. It is my plea to the city council, and I think in agreement with my neighbors, that this project halt immediately and maintain the cease and desist order. Thank you.
Thank you.
Hi, my name is Elizabeth Lasso. I live at 99 Armiston Street in Brockton. This is definitely not my first time in front of this board, but thank you all for being here. I personally know someone who had used this New Heights dump to bring in debris from other towns and other construction projects and dump the dirt and the gravel and the brick and the debris from streets and pavement and rocks. That's not site cleanup. I hope I don't need to define that to any of you people here. That's not site cleanup. That's BS. He's been running a very lucrative business from that site with no plans of making a sports complex. The whole entire contract that he had with the city was to make an indoor sports complex that would have indoor fields, have a certain amount of capacity to have indoor fields and outdoor fields. His new site plan that's in review right now has got nothing for an indoor sports complex whatsoever. It's got storage buildings for a maintenance crew of trucks and vehicles so he can continue with this work. So not only does he want to continue with this work, but he wants to do that kind of work around an outside soccer field where kids and families are going to play. God only knows what's in that debris. They're not even permitted to do that work that they're doing. They're not permitted. They are going to get fined by the DEP, and we're asking for the EPA to come in and test the soil because God only knows what's going on with that. And you know, we get plenty of enough rainwater and groundwater that seeps into the neighbors and the abutting properties that could be toxic and harmful to people. They have 2 cease and desist orders that not one person from this city has enforced. Not one. We had to go to a traffic commission meeting to even let people be aware of it and know about it. His connections are obvious. And if you people don't see through this BS, then you shouldn't be on this board because that's not site prep. That is not site prep. That is a blatant disregard for the law of Brockton. It's a blatant disrespect to everybody who's around that area. And if you guys believe his lies, again, you shouldn't be here.
Thank you.
Again, not permitted. Not permitted. He doesn't have one permit from the state to operate that. And do you know that he needs to have those permits to do that kind of site work? Do you know that? And if you need me to bring the person who did do business with them in front of you to attest that they brought in materials from other towns and other places, I personally have witnessed New Height construction trucks in other towns around us bringing stuff here. The people have had enough. Please, for once, could Brockton do something for the people instead of people like that who are connected with people who they know people? Thank you.
Sir, do you have anything new to add to this?
I do. My name is Jamal Brathwaite, 18 Parkview Lane. And as a Ward 6 resident, I'm asking the ZBA to, 1, keep the cease and desist order in place. And secondly is to enforce it. Like my fellow resident just acknowledged, we just don't feel the city of Brockton is enforcing the existing cease and desist order. So that's point number 1. Point number 2 is that the city of Brockton should really step up to have the Department of Health, as well as maybe the EPA and the DEP, Department of Environmental Protection, to come down and test the soil to identify, are there elements that are hazardous to human health? Please note that there's over 100 single-family residences that abut Claremont as well as Sprague Street. So if each house has at least 4 people in their house, we're talking about a population of over 400 people. And so I feel that the City of Brockton, ZBA, please step up, reach out to the Department of Health here in Brockton, ask them to do soil sampling. And lastly, I think it's also important is there's 3 deed instruments that govern this site that is more than 32 acres of land. And when I was reviewing the deed, I noticed that for the Sprague Street parcels, the sports complex, phase 1 was supposed to be completed within 3 years of the closing date defined in that deed instrument. We're past that date now. And so I'm asking that the ZBA step up, reach out to the city solicitor and ask them to review the deed instrument. Are we currently in breach of that deed between the city of Brockton and New Heights? And if so, can the city solicitor please step up, send out a formal communication to gain a timeline of when this sports complex is supposed to be built? At the moment, like my fellow neighbor acknowledged, I mean, nothing there looks like site prep at all. So for someone to say that site prep and for the ZBA to potentially take that and take that at face value, I think is just wrong. Please act in your fiduciary duty to represent the city of Brockton and enforce the cease and desist order. Thank you.
Thank you. All right, if there is no one else that wants to speak, sir, I would expect that you would have something new to offer.
New to offer?
Yes.
No, I'm just adding on. I appreciate all the folks coming out here tonight. I just want to say that, you know, I've been a resident, you know, of Brockton all my life. And, you know, I left for 25 years, and I've come back. My parents are still here, and so forth. Actually, I told my wife that I did not want to come back because I seen the decline of the city, which is very disappointing, you know, to me. But for some reason, you know, we was able to find a place, a wonderful place. That's what we thought, until we heard the noise and so forth. did not understand exactly what was going on until we was informed by the earlier person here that came to our door to give us this information on what's supposed to have transpired off of Howard Ave, which is supposed to have been that sports complex. Now that I understand the information that's come forth, it's supposed to have started in 2017. All these folks that has come up here today speaks the truth. And for me, when I used to ride up and down the street from work and so forth, some of these folks are saying exactly what I've seen. Trucks coming from different areas and so forth, pulling in. I actually thought that was a dump site, but I was wrong. At the same time, I have, my wife that's sitting over here that works nights, 12-hour shifts and so forth, working from 7 p.m., coming home 9 a.m. in the morning, constantly hearing this noise. We had no idea exactly what it was, because at the time when we signed for our house, it was in 2019, a day before the pandemic had actually shut everything down. So we started hearing all this noise, and come to find out exactly what the folks has been expressing their feelings about, something that was positive, but actually it's negative. And the impact on all these people and what I see coming down that road, you can see these mounds of dirt, debris, logs, and so forth. In my environment, in that circle, for Mike, my heart goes out to you. Walking around that area, especially in the fall, I can see straight through there how they tore up all that land. It's been 5 years. If you're not going to build that complex, then you should not be out there digging. Someone is letting this go on. There's no business for it, no reason behind it. I really am disappointed being a resident of Brockton and coming back, and now I'm in front of you all. Please keep that cease and desist order in place.
Thank you very much.
All right.
Do you have something new to offer?
Mr. Chair, I beg your pardon. I'd just like to speak about something the attorney said.
You need to come up to the microphone, and I really should limit you to several minutes. I cannot let this go on.
1 minute is all I need, sir. 1 minute is all I need. The attorney spoke about the economic impact it was going to have on his business. I want the city council to think about the economic impact that this has on the residents. Property values directly impacted. The beauty of my home has diminished at least 50% due to the matter of him cutting down the tree line. When I pull into my driveway every day, as he said, I see mounds of debris, mounds of dirt, mounds of boulders. If I was to go to try to sell my home right now, I would not get asking price. I'm one of the higher taxpayers in the city of Brockton. I live at 49 Livoli Road, directly abutting the property again. Please, city council members, take into consideration the impact that this is having on your residents that you represent. Thank you.
Thank you very much. All right, if there are no other speakers,
I think we got a couple, Mr. Chairman. We've got a few. You want to go first? Or?
Hi, my name is Anna Shapiro, and I live in District 6. So I heard that they were able to buy 20 acres of land for some $240,000, what is around 10 cents on the dollar. on the presumption that they're gonna build a sports complex. Now, there's no sports complex. I think the sale of the property should be revoked because that was the stipulation. That was a stipulation that they're gonna build a sports complex. So if they don't keep their end of the bargain, I think the city should take back the 20 acres of land for $240,000 because I think you can't buy 1 acre for that kind of money.
Okay, ma'am, just keep in mind that this is not the city council, this is the zoning board of appeals. They have appealed the decision of the zoning enforcement officer, and they have a right to a hearing so that we hear his side of the story. What you're talking about is something that is way beyond what this board has jurisdiction over. So
I
just realize that.
I understand it. I just wanted to point out the injustice, what we are suffering here.
Okay, thank you very much. All right, I'm going to close that portion of the hearing, and now, is there any public official that wants to be heard on the issue?
I still count, Mr. Chairman. Mr. Chairman, Commissioners, I think that the folks here have been pretty clear. I know myself and the representative are going to come up and we're going to say our piece, but really it cannot be said better than by somebody who lives next to the project. To speak directly and immediately on the matter at hand, losing the cease and desists loses the city whatever leverage it may have in an attempt to terminate the project that I think it's very clear the folks at home do not want, and attempt to get back on course to a sports complex. We should be having meetings about in front of the planning board with plans of a complex in front of us. And we should be hearing that and we should be arguing that. We are not. We're arguing about a different business that's coexisting or not coexisting in the same property. What we're looking for is an end to the gravel, to the loam, to everything like that. It's put up or shut up time when it comes to a complex itself. That's been the discussion and the goal for myself, my predecessor, my predecessor's predecessor. That's been the discussion. That's been the goal. This is not where we're at. So the cease and desist give the city leverage. They give our code enforcement personnel, like the superintendent here, the ability to have a little more room to act. We've been able to take this matter to court. It's being dealt with in the courtrooms where really we got to trust the lawyers. But the biggest thing is we cannot have the gravel and the loam. It's too big, it's too far, it's too much. The residents don't want it. The city's gonna have to do what it's gonna have to do, either finding something with the DEP or the EPA or getting something sorted out in court. But what has to happen is these cease and desists need to be upheld, they need to remain, and we need to continue to have that leverage and have that ability to continue to keep this matter closed. We do not want this restarting. We do not want that opening given. I think that there'd be quite a few folks here who would agree that we can't really afford it. So I ask you, specifically located to this matter, and if this ever comes back on the rest of the matter, no gravel, no loam. I don't want, to have to come back here and testify in front of this board again unless it's something to do with an actual complex and the construction thereof. So I appreciate your time. I appreciate you listening to, all the folks who have come out. And I'll be around if anyone has any questions. Thank you.
Thank you.
Good evening, Chairman and members of the Zoning Board of Appeals. My name is Michelle Dubois. I'm a state representative for Brockton. I'm the state representative for this area. I live at 6 Bank Street, and prior to being the state representative, I was a city councilor for this area in Ward 6 for 10 years. So I have some points to bring up, and I'll try to be as brief as possible. I numbered them, and I know I'm going to be missing some of them, so I'm going to do my best. But I think the residents really, and Councilor Lally really got across some of our issues. I want to start out by asking you to deny New Heights' request that you overturn our zoning enforcement officer's determination, our chief building inspector's superintendent's determination to issue a cease and desist order, both on both of the parcels that I refer to as the sports complex parcel. That's the parcel that got sold for $240,000 based on an RFP that was glorious and had parking on the smaller parcel that the chairman referred to. I believe that's around 10 acres, so it's small in a way, but it's still kind of big. And in the RFP, that land was also used in the sports complex. You could look it up. It's a city document, so it's a public document. I hope some of you have seen it already. And so I hope that you will uphold the zoning enforcement officer cease and desist order this evening with your vote. Number one, I really do not think, and this is no intended offense to any single member here, I really appreciate all your volunteerism and the hours and the time you put in, as well as the chairman and our superintendent of buildings, and making sure that everything you do is upstanding and appropriate. But I just don't think that the planning board, the Zoning Board of Appeals is the appropriate body to circumvent site plan review. Because the amount of materials the New Heights attorney is saying that they're going to be moving around, even if we take them at their word, which up until now really has been like a shell game, but if we want to take them at their word, the amount of soil they're removing really should have a plan. The city should have looked at it. The city should talk about where the water is going to flow, how they're going to do it, what are the hours of operation, and I'm sure many other standard operating procedures that would happen in most every municipality, that I'm sure that the building inspector, our city solicitor, and any number of employees here in the city and professionals in the field could tell you what normally happens, and that is going through a proper process through the Planning Board of Site Plan Review. So I just, no offense to any member here, I just don't think that this is the appropriate body to take on that determination to allow them to start digging and excavating and moving things and circumventing the flow of water and doing all these other things that they've been doing without oversight in a really scary manner, like piling many cubic yards and tons of flammable wood chips on the, what I call the sports complex parcel, within like 20 feet of a single family home residence. And even after a fire broke out there and the fire department had to come out and put it out, they didn't move it. I spoke with the DA, so I don't think it's the appropriate venue, so I ask that you refer them back to the appropriate venue. Number two, at every step of the process, New Heights, Greater Brockton Sports, Mark Rukas has circumvented the process in one way or another. We have an email from the Department of Environmental Protection telling me maybe 6 months ago that New Heights had planned on trying to get industrial transfer station license from them. He never said that to the city, but that's what he told them. He told the residents that it was site plan review. He told the city, it was site prep for a sports complex. He told the city many things that he told the city. So at this point, giving him the benefit of the doubt, no offense, because in the end, I really hope that it's a sports complex, and the process might be worth the effort. But at this point, the city has 2 cease and desist orders against this company. A judge issued an injunction on the remove a park parcel, which is still enforced. So even if you were to lift the cease and desist on the remove a park parcels, there is a judge's injunction, and releasing that cease and desist would just undercut the city's position in that matter, and I don't think it would be to the benefit of the residents. It would be to the benefit of the illegal operator, but the state is still going to move forward with its remediation plans. And so I just ask that, I live by the motto, don't listen what I say, look at what I do. And I've only come to this in the last 5 years because it's a really clear-cut way to see that we can regulate and be friendly regulators, and hopefully, in the end, Mr. Rukas will be happy and the residents will be happy and we'll have a sports complex, but we might have to be a little tough through the situation, and it's unfortunate that we can't be more friendly about it. I would like to get to a point where we could be. But I do think that we should not take him at his word at this point, because up until now, we've heard a lot of stories, and it's to the detriment of these residents. Number 3, lifting this cease and desist order undercuts the city. It's the city's job to make sure that the rules are followed. It's not always easy, especially when you have very upstanding, respectable people that you have to then say you're not doing this correct. It's not easy. I'm not saying it's easy, but it is the city's job to protect the residents. And that's what I see that this cease and desist order did. And we aren't precluding him to do work there. We're just saying go through the proper channels, go to the planning board. Let's make sure everything is appropriate. Number 4, lifting the cease and desist order undercuts the DEP. The DEP has done, since August of 2021, has been doing investigations into this site. And I hope that each of you have seen this, but the DEP, I just wanted to enter in the record, on June 7th, 2022, they issued a notice of non-compliance in an enforcement document 000134422 to New Heights Builders of Mass, and in it, it says that on August 3rd, 2021, the Department of Environmental Protection conducted an inspection at New Heights Builders facility located on Howard Street in Brockton. The DEP determined that non-compliance occurred in violation of one or more of the laws, regulations, orders, licenses, permits, and approvals of the Mass DEP. The notice of non-compliance, what it says is it says, under the header of description of noncompliance, August 3rd, the DEP observed New Heights operating asphalt, pavement, brick, and concrete ABC recycling operations, called ABC, it requires a permit. That is subject to the requirements of 310 CMR 16. Site assignment regulations for solid waste facilities. The owner stated that ABC was being brought from other locations for crushing at site. Operation of a recycling operation that accepts and crushes ABC from off-site and which is not located in an active quarry or gravel pit or at a site of generations requires a recycling, composting, and conversion permit pursuant to 310 CMR 16.05, which states, and it goes on. So you could read that on your own. They have 60 days to remove those piles, and it says that they're supposed to communicate their plan to the DEP. I had a meeting with the city like a week ago, maybe 10 days ago, and they still hadn't heard of a plan. I called the DEP maybe 5 days before that, and I'm going to follow up with them. At that point, they hadn't heard of a plan, but they are required. So there's a DEP notice of non-compliance. There's a judge's injunction on this site. And we have the city cease and desist order. We have residents been so fed up that they brought their own case before you and made some mistakes because they're just residents, just like, I'm not an attorney, and we made some mistakes, but we got that out there, and them coming to testify at that point is what facilitated the building inspector in the city to look at what was happening, because it hadn't been communicated appropriately to them as to what was happening. So it undercuts the DEP's effort to really just protect the health and welfare of the residents here. It got so bad that I had a meeting with the Department of Environmental Protection's Commissioner, Martin Suberg, probably 45 days ago on Zoom, and he had all the southeastern area people there, and explained to me that there was an investigation, and he couldn't tell me all the details, but I explained to him what I saw, and he said, the piles of trees, a lot of the things on this site are a problem. And then they followed up with that, with this notice of that they're operating outside of the law and that they have to clean it up within 60 days. And it's difficult because there's so much going on, and it's the summertime, and it's very hot today, and residents are have been called here many times over the last few months for different types of questions, and it comes to a point that it's like a delay tactic. Like maybe the residents won't show up this day, and they'll get some approval that is if you just want to follow the rules, there is a clear path to them building their sports complex. I have looked at the new site plan, which is very different from the original, but I'm open, you know, because, you know, it's not my business, so it's up for the developer to make those determinations. So I'm open to this proposal, but in some ways, it actually looks like a transfer station, the building to me. But I am not an engineer. I'm just a human being looking at it with my eyes, looking at what I see. And so they'll have to go through this process. Why would we circumvent them being able to be, the planning board demanding them to be honest and earnest about their plans with taking away a cease and desist order? It's like we're communicating different messages. Number 5, the money. The operation at this site has been determined by the city, the state, the DEP, a judge, to be unpermitted industrial use that is not legal. So, with all due respect, the attorney saying that there's this revenue loss, well, why are we facilitating illegal operation revenue collection? Go through the permitting process, follow the appropriate rules, and then whatever will be, will be. But we should be demanding, and this money issue, do you know, I was told that for every truck that gets dumped in there for the last like 6 months or a year and a half or 3 years or 6 years, it's like $600, $800. I'm not in the recycling ABC business. I don't know the exact number, but that's a lot of money going in and out. That is not permanent, that is not taxed, that is not, I don't know what type of materials is going in and out because there's no ABC permit. We've seen waste cleanouts going in and dumping. We haven't seen them dump, but we've seen them go in, so that's a problem. Number 6, I only have 2 more. The history.
I want to interject that I would appreciate if you stay right to the issue. In other words, when you say you heard, you know, somebody told you, really, that's kind
Okay,
of
well, the issue with the DEP commissioner is real.
Well, let's stick right to the point.
You got it. History. 2015 is when this all came up. So, you know, there's been 7 years here. So the idea that the urgency, right now, it's literally the height of costs for construction, demolition, debris. So I can understand their financial urgency to get a carte blanche from the Zoning Board of Appeals that they can just continue with their illegal operation. And then that will send a message to every other person that owns any tract of land in Brockton that we're just open for business for illegal ABC operations. And that's going to cause elected officials and residents a lot of heartache. I grew up on Andover Street. My house was worth like nothing. The house that I grew up in right now is being sold for close to $500,000. Like 7 years ago, my mother sold that house because she couldn't maintain it at her age for like $200, $210. So the values in this neighborhood are exponentially increasing. And having this illegal industrial site operate is really hurting our tax base. It's hurting the residents by far much more with their financial loss than anything that the proponent is saying. So they had a lot of time to get in line. So number 7, nope. And finally, my reading of the agenda, and I could be wrong, but my reading of the agenda, I thought this was only going to be about lifting the cease and desist order on the sports complex land. But what I heard the attorney say was that they would like the cease and desist order lifted on the sports complex land and on the land from Remover Park. The land from Remover Park, so that is included now. That land is the one that's under the DEP command to get cleaned up, and there's regulations. So I just think that giving them carte blanche is a bad idea. I'm very nervous about what that would mean to your city and to my city and to the mayor and to the legal department that have to defend against this. And so I hope that you will definitively say no. And I'm hoping that the proponent will then be more communicative with the residents, and we can get to a stage where we can work together to get this project done, and that they won't be called in next month here, and the month after here, and the month after here, and just kind of like, it's like an abuser mentality of what's happening. And I would like to change that around and help the developer make this happen, but maybe it's going to require some tough love on your part, and I hope that you will deny their request this evening. Thank you.
Thank you. Is there any other elected official that would like to be heard on the issue?
I'll be brief.
No, that part of the hearing is closed. All right, I'm going to close that portion of the hearing. That concludes the public discussion of this issue. I am now going to open it up to discussion among the board members. Board members.
Mr. Chair, can I ask one question to the petitioner?
Of who?
Of the petitioner?
I don't want to get into a discussion.
It's just a quick question.
All right, I'll allow one quick question from the petitioner.
When was the land for the sports complex purchased?
2020.
2020? All right, because
Yes,
we
sir.
heard 2015 and 2017.
I think there's some understandable confusion between the sports complex parcel and the Remuva Park parcel. Everything I've heard so far is about the Remuva Park parcel, which is subject to a preliminary injunction, a DEP order, a Concom order. We're trying to work those things out. Hard stop, separate issue is the sports complex parcel purchased in 2020, to answer your question.
Okay, thank you.
But you are referencing both parcels separately, correct?
So tonight's proceedings involve what I'll call parcel 53 and the sports complex parcels. Remuva Park.
Separate issues.
Two separate issues.
Right.
Remuva Park, entirely separate parcel from those two.
Correct. That's how I understand it also. Thank you.
Sure.
If I may just correct the
No,
record.
I'm sorry.
There was a mistake on the, there's just a mistake on the record. I'd just like to clarify, and then, just to be clear, the land went out for RFP, and the project was selected in 2015, 2016 time from the RFP committee, and since then, the land has been captured. And it is accurate that the money didn't transpire till 2020 because I believe it was like put up or shut up time. But this land has been locked up and unavailable for anyone else to purchase since 2015. And it's been the proponents' delay tactics that hasn't had it closed till 2020. Thank you.
With all due respect. All right, now, board members. Time for deliberation on this. There's two issues before us.
I find it difficult to, can you hear me? I find it difficult to overturn the building inspector's decision. Like any project we have in the city, I'd like to see it, I'm also the planning board representative to this board. Like any project, I'd like to see it laid out and organized properly. So that's my opinion.
I'm sorry, I didn't catch the first part of that. I didn't catch the first part of your statement.
What, the first part?
Yeah.
I find it hard to reverse the building inspector's decision.
Okay. Thank you.
Now, the issue I see with this is this was sold to be a sports complex. It's zoned for a sports complex. And in order to get it to be a sports complex, it's going to have to be leveled off. And right now, all the vegetation, the trees, that's all gone. So, I mean, what else are you going to do with this lot now? If you want to put residential on there, you're going to have to remove even more. And I feel for the residents, you know, but I see this eventually getting leveled off. And
I think in that aspect, that's why it needs to get to the planning board. Organized, structured. We know what's going on as a city. It's not just, you know, the zoning appeals the right to say that. It needs to be kind of guided in the right direction, and obviously the neighbors are kind of living it right now.
Right, there's a couple of issues before us here. The area where we saw all the dirt piles right now is in litigation. The area on your map that shows the location of the proposed fields is the issue that's before us tonight. They need to go, my understanding is they need to go for site plan review and planning board approval. A developer can't just come in and arbitrarily rip up land and create a new complex without approval for drainage, where the water is going to go, the water mains that have to go in there, the roads, the access, all the things that are necessary to be controlled when a new development is put in place, whether it's a sports complex or it's a housing project, whatever. My understanding is they have been before the planning board. The plans have not been finalized. Either site review or planning, I could be wrong.
I haven't seen a review on it.
All right, so site plan review has not been granted for this location. What they're asking us to do tonight is to take away the need to get that site plan approval, to lift the order that has been given by the building inspector to cease and desist operations until you get approval from site plan review and planning. Now, the planning board in Brockton is the permit granting authority. It's not us. Our job is to look at the zoning in the city, and if somebody has a problem with zoning in the interpretation, whether on their side or the building inspector, they have the opportunity to come to the zoning board for a hearing to propose to us what their problem is, and we may be able to grant them a variance or a special permit, which we do on a regular basis. If they're not happy with what they hear from the zoning board, they have the ability to go further to the court system. So what's before us tonight is a request from the petitioner that they are not happy with the fact that the building inspector has made a determination that there is now a cease and desist order. You cannot continue to move earth and create a sports complex willy-nilly without planning board or site plan review. And if we take away that ability by lifting this, then I think we put the planning and site review in jeopardy. And what does that have for an effect on any other project that's going to come into the city? So in this case here, if there is no site plan review done with this and planning board approval, a developer could come in and pretty much do whatever he wants to do, change the topography, make the water go wherever he wants to go, put water mains wherever he wants to put them. This is the planning board is the organization that determines what the petitioner needs to do to create a project. It's as simple as that. So there's two issues here. One is a separate piece of property. The one we're dealing with right now is the area where the sports complex is going to be located. We've heard all kinds of things about debris that has been brought in and stored there, and you know that we can discuss that ad nauseum. But the point here is tonight is that if we lift or vote to lift the cease and desist order, then I think we've put the planning board, site plan review, and any other agency in the city in a very disadvantaged position where the city will really kind of lose control of what goes on up there. So there is a system in the city that has to take place, and they are coming to us to circumvent that system. That's the way I see it. Now, I don't know how any other board member sees it.
Yeah, Mr. Chair, I agree with you. I think it sets a bad precedent for us to overturn the cease and desist that has been put in place. I think the city has a process, and you know, just like any other developer or any other person that's trying to come in front of the city for any project, they have to go through that process. And if they're not in compliance and we have a cease and desist order, they should follow those orders. And from what I'm hearing and from folks are saying, it doesn't sound like that they're adhering to even those cease and desist orders. So I think we need to do our due diligence and enforce those orders, but then also make sure that we don't set a bad precedent and then undo those orders going forward. So I'm in agreement with you.
I think that would also reinforce the part on the petitioner to get to site plan review, which would start the process. I'm sure the neighbors don't want to see that hills in a churned
Mounds.
earth. The city wants it developed, or at one point wanted it developed. So to get the site plan review, I think the quickest way to be to uphold it.
So the land up there is zone C7 for a sports complex. If the potential developer does everything that the city requires in its ordinances, then the project can move forward. It would appear right now what they're trying to do is just circumvent the process. And they're trying to use this board as a board to overturn the decision of the building inspector that said you cannot proceed any further until such time as you get permission from the planning board and site plan review. That's how I see this. I don't know. That's only one man's opinion.
Motion to grant.
Second.
All right, let's clarify the vote now. A yes vote will be a vote for the petitioner to overturn the decision of the building inspector. That was a yes vote will overturn the decision of the building inspector. A no vote will sustain his determination. Everybody good with that? Okay. The motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lantis? No. Mr. Spinola?
No.
Mr. Sweeney?
No.
Ms. Hodges?
No.
Chair Galligan?
No.
Mr. Chair, that's 5 in the negative, 0 in the affirmative.
Okay, the vote is, hold on just a minute, let me finish. The vote is no votes in the affirmative, 5 in the negative. The request to overturn the decision of the building inspector is denied. The decision of the building inspector is sustained. Now, the petitioner has also asked us to look at a second parcel, which is this parcel 053, which is outside of the sports complex part of the parcel. Parcel 053 appears to be in that section of this locus that is the subject of the court hearings relative to the cease and desist and whatever the city has brought against where the dirt piles are. In my investigation of parcel 053, it is a very small parcel, and you probably would see it on the chart that you have. Somehow, whether it was an oversight that this small parcel was left out of the original court proceeding, or it was a Scrivener's error that it was not included with the other parcel that is now within the courts. They are asking us to overturn the cease and desist order on this small piece of property which sits outside of the sports complex parcel. What we need to do here is determine whether or not we want to overturn the decision of the building inspector to take that out from underneath the cease and desist, or we will support the building inspector and keep it under a cease and desist order. Does everybody understand how that's laying out. So this is a separate parcel, separate from the parcel we just voted on, which was the sports complex. Everybody understand that? So this is a very small parcel. It's called parcel 053, and that's the one they're asking us to also overturn the decision of the building inspector. Any comments?
Yeah, I believe that one was an error.
When you look at all of the parcels that were listed, and there was dozens of them, it is a possibility that that one was missed. That's a possibility. Or it could be that when it was being transformed onto a document, that it got missed. But when you look at it on the chart, it's certainly part of the whole parcel. It would be unlikely that you would put a cease and desist order on all of that property up there and leave this one tiny parcel untouched. So we're being asked to overturn the decision of the building inspector, who said that the small parcel of 053 is also included under the cease and desist order.
A motion to grant?
Second?
All right, clarification on the vote. A yes vote will support the petitioner and overturn the decision of the building inspector. A no vote will support the decision of the building inspector and maintain the cease and desist order. Everybody good on that? All right, clerk, please call the roll.
Mr. Lannis?
No.
Mr. Spinola?
No.
Mr. Sweeney?
No.
Ms. Hodges?
No.
Chair Galligan?
No.
Mr. Chair, Mr. Chair, that's zero in the affirmative, 5 in the negative.
I'm sorry, I spoke over you.
That's okay. 0 in the affirmative, 5 in the negative.
The vote is 0 in the affirmative, 5 in the negative. The petition to overturn the decision of the building inspector is denied. The decision of the building inspector is sustained. That's it, we're done. We are going to take a 5-minute break. Okay, I'm going to reconvene the board meeting. We will now proceed to case number 1. 2271, the petitioner Jeremy Hayes, 7 Elman Avenue, Brockton, Mass., seeking permission to construct a new wood deck with stairs in an R1B zone located at 7 Elman Avenue.
Good evening, I'm Jeremy Hayes. Coming before you folks to, obviously I had a bad deck, had to take it down, I need to put a new one up. And it's, according, I guess it's a little too large. And I'm just looking, I guess I don't know what you guys need from me other than I think you have everything.
All right, you're asking for a variance from the board.
Yes.
Variance means that you want to build too close to the property line.
Yes.
Okay. What you need to do is to convince the board that you have a hardship that is unique to you relative to this porch. Now, in other words, can this porch be put anyplace else?
Well, no, because so the way that, so what I did is that this was there prior, from the prior owner. The wood and everything was rotted out, so I had to take it down because it was unsafe. And the way the house is constructed, my kitchen door actually goes to that side of the house. So there's a door there now that there's nothing there to stop it. So that would be the hard. I need to replace it. And what I thought I was doing was replacing something that was already there. So I didn't.
Thought what? I didn't catch it.
It's something that was already there in the first place from the prior owner. So I was just basically replacing it.
Once you took it down, you lost your grandfathering.
Okay.
So you're okay.
Yeah.
So you're asking for a variance to allow the replacement of the porch. Is this porch any larger than the one that came down?
It is about 2 feet bigger than the prior one. 2 feet.
So you're encroaching on the sideline more than the other porch that was there?
Yes.
Could you move the house in order to make this porch fit where it's supposed to go?
No, the house can't move.
So the foundation of the house is a hardship?
That is correct.
So you're telling us that your hardship is the location of the foundation of the house and the layout of the interior of the house dictates that this porch needs to go where you want to put it?
That's correct.
That it?
That's it.
Board members, any questions?
Seems,
Pretty straightforward, yeah.
going from what we just saw, this seems pretty standard, yeah.
When I went up and looked at it, I didn't think it was going to impose on the house directly up against the side of it. I figured that there's, when you look at the houses that are up there, they're all very similar in side yard setbacks. They're all narrow lots up there.
Right, seems to conform with other properties in the neighborhood.
So if there's no questions, I'll close that portion of the hearing. Is there anyone here that wants to speak in favor? I'll close that portion of the hearing. Is there anyone here that wants to speak in opposition? I'll close that portion of the hearing. Is there any elected official who wants to be heard on the issue? I'll close that portion of the hearing. That concludes the public portion, and I will now open it up for discussion among board members. Board.
I don't have an issue with it. I think it's,
Yeah, it seems pretty straightforward.
You get a chance to look at it?
Yes, yep. Yeah, so it's pretty much replacing, I seen pictures online too of the original one. So I don't see an issue with that.
This porch, I'm just going to open it up for a question. This porch is not going to be enclosed. It's an open porch with a railing, right?
That's correct. Stairs right down to the driveway, yep.
Yeah, seems, same here, seems pretty straightforward. Yeah, you can't move the foundation. I feel like that's where the door is to the house, and I feel like he needs a porch, he needs steps to go up to that door, so seems like it makes sense to me.
motion to grant.
I'll second.
Motion has been made and seconded to grant. Will the clerk please call the roll?
Ms. Delanus?
Yes.
Mr. Spinola?
Yes?
Mr. Sweeney?
Yes.
Ms. Hodges?
Yes.
Chair Galligan?
Yes.
Mr. Chair, that's 5 in the affirmative, 0 in the negative.
The vote is 5 in the affirmative, none in the negative. The petition is granted.
All right, thank you.
I will just caution you to make sure that when you build this, build it to the plans that were submitted to the board. Good luck.
Thank you.
Next petition, 2272 for 753 Pleasant Street, has been withdrawn. The next petition's 2273, the petitioner Crystal M. Roach, 161 North Quincy Street, Brockton, Mass., for a special permit from Article 2, Section 319, Kennel, to seek permission to have a dog training and daycare at my home in an R1C zone located at 161 North Quincy Street.
Hi, good evening. I'm sure, let me adjust this real quick.
It'll pick you, it'll...
Okay. So my name is Crystal Rossborough Roach. I've been living at 161 North Quincy Street for a little over 6 years. If you read a little bit about my background, I was in the military and I worked as a corrections officer, and in both jobs, I did corresponding needs dog training service program. I don't know if you guys are familiar with the needs dog training, but it's training dogs for kids with special needs, PTSD victims, veterans. In addition to that, I assisted with homing the dogs on weekends because they learn training at malls, stairs with people that things that you don't have in a jail setting to use. So basically I'm requesting under Article 2, Dog, Section 319, Kennel Licensing, but I did want to be clear that I would either need like a hobby kennel or commercial kennel licensing. That is not because I have any interest in litters or selling dogs. That is, I don't know if that's any concern for you guys or any of my neighbors potentially, but it would be servicing a lot of those people that trust me, that have known me for years with their needs dogs, with doggy daycare, when they go on vacation, you know, these special dog trainings, whether they're cadaver dogs or ones that I've had from the military, they can't just be put in kennels. It's just not the type of need basis that they have. Along with my application, I gave photos. If anybody needs any extra, I do have some with me. My yard is very big, has shaded area. I have a doggy door that's open at all times. If I did have dogs staying overnight, it would be under 6, absolutely. I do only have one dog. It's a husky. He's 6 years old and loves to sunbathe, so he's not an issue. But I close the doggy door at 9 o'clock at night. I don't open it until 8 o'clock in the morning. So basically, I am asking for the special permit to hold up to a commercial license. Whether it needs to be defined as a hobby or a kennel, commercial kennel at this time is a little unknown. I would never have more than 6 dogs on my property just for what makes me comfortable purposes. And that's it, if anyone has any questions.
Mr. Chair, if I may, what's the size of your lot?
I'm not sure the exact size.
If you had a rough guesstimate, is it a quarter acre, half acre?
I'd say a little under a half acre.
Under a half acre?
Yeah. And it's entirely fenced in.
So you did not submit a site plan that shows your property?
I didn't know that I had to. I just went through the process with the zoning board and checked off all those balances.
I guess what's preventing you from opening in a commercial area or a commercial zone or a commercial business?
I didn't think there was anything preventing me. I was just told that I should get commercial licensing if I'm going to have dogs there. I wanted to go the legitimate way and not just...
Right, but I guess what I'm saying is in a commercial zone. Like, there's a doggy daycare, I believe, on Pearl Street. They're in a commercial zone. I'm just,
it's my residence, and I just wanted to shift it to, like, basically a business residence for those people, just in the comfort of my own home, instead of having, like, employers and doing it that way, because I don't plan on expanding. It's more of something that I want to do for people that I care about, because dogs are, like, best friends to me. Like, I understand the need to have a lot of the clients that I had through corrections, the people that I met and the type of business relations that I've had with these people, they're overly concerned about what's going on at legitimate commercial doggy daycares, and I would never be interested in having dog runs and, 20 dogs in one run, because even the standards that they have in this state, I think, are very concerning because of the pack mentality of dogs. So I just really enjoy that low-key, under 6 environment with dogs I've known previously that are needs dogs or cadaver dogs or drug sniffing dogs. From working in corrections, I have a lot of friends that are on canine units, and they really respect my relationship with dogs. I know in what I sent with the packet, I said that I know it's a little woo-woo for some people, but I do animal certification communication with dogs. I do Reiki with animals and humans, so I just find that my relationship with dogs is very simple, and I don't want to overcomplicate that by buying commercial land and making it this business and hiring people that may or may say they love dogs and maybe they don't. Like, we just have this nice vibe going on, and I just enjoy it at the residence. So that's why I was just requesting.
So if I was a neighbor of yours and this was granted, how does my life change at all?
No.
Okay.
So I don't want to say not that it matters, but between all of us in this room, I know specific dog breeds, and I would never take in a dog. I'm not saying anything bad about pit bulls. A lot of the times it's the owners, but sometimes they have this dramatic personality, or whoever they're around, they become very protective of, and that can be a big concern. It can cause dog fights. So we're talking about German Shepherds, like well-trained golden retrievers. So there's no difference, no barking. I mean, it's funny because I thought to myself, if any of my neighbors showed up that I didn't know, because I know a lot of them really well, we have a couple dogs like 3 doors down. It's the owners' dogs, but they bark a lot, and they kind of let them out at like 6 in the morning, and they're out until 11 at night. And I'm like, don't have that issue, because I have so much respect for my neighbors. Even when I moved in, I brought them cupcakes and cookies because I'm weird and that's how I grew up. So I would never disrespect my neighbors, and I'm not doing it for the money. I'm doing it because of the respect that I have for the people that I've worked with. So I would never overdo myself for my own sake, for money's sake, or disrespect my neighbors.
Do you have a process for the waste that the dogs make? I mean, if I was next door, I know that You know, sometimes 6 dogs can kind of add up in the yard. Is there a process? Is there,
So
your process be?
I personally, it's either every day or every other day that I clean it up. And sometimes we reuse it towards like the grass or like for plants. Like we have a process to use for like our gardening because sometimes like dog waste is good in small amounts for planting. But I get rid of it in an unhazardous way. I don't like leave it out there or put it on anyone's lawn.
Like again, I'm thinking as a neighbor, just like in terms of smell and stuff.
Oh God, no, no.
Okay. Anybody else?
Are they primarily, like when they are outdoors, is it like in a fenced-in backyard? Or?
It's an entirely fenced-in backyard, yes. I have a few like dog ramps and obstacle course things too, because I know they really just enjoy being on things. I have a couple coolaroo beds. I have 2 dog houses in the shade in the back area, just in case for some reason they just wanted a moment of peace, and a couple crates. I have a hammock, and some of the dogs know how to get in the hammock, and they will literally hang out in the hammock. It's something else. So they have that freedom to do whichever.
Have you spoken to any of your neighbors about what you plan on doing?
I talked to my neighbor. I would have had them write an email to you guys, but they are over the age of 78, and they just think I'm the cutest thing. I'm like their new granddaughter, adopted. So I know my neighbors, but they're not the type, like, they're not gonna, they're just busy and they work. They're not gonna show up here, but they're like, we're rooting for you and we get discounts like every other month, right?
So you said that you don't plan on expanding past 6 dogs, so 6 dogs is the cap that you're
Correct.
going to have it at?
It's just a personal choice. I mean, I'm aware that there's a commercial thing that says, oh, 6 to 10 or over to, this is not of an interest to me. I think too many personalities in one room, whether it's a dog or people, is not a good idea.
Would these dogs be delivered to you each day?
It depends. If they're people that I work with that want me to go get the dogs, I can do that. So there isn't going to be this influx of just people pulling in and out of my driveway. There will be some people that will drop off the dogs, but I also go to get the dogs.
Any other questions from board members? Everybody's good? Okay, I'll close that. I'll open it up for anyone that wants to speak in favor. Seeing none, I'll close that portion of the hearing. Is there anyone here that wants to speak in opposition? Please come forward. You just step aside and let her have the podium. Thank you.
Good evening. My name is Marguerite Duchesne. I live at 175 North Quincy Street. I'm asking you to vote no on this request.
Could you speak just a little louder?
Oh, sure. My name is Marguerite Duchesne. I live at 175 North Quincy Street. I'm asking you to vote no on this request. North Quincy Street is a very busy street. I'm worried about the additional noise, traffic, and sanitation issues that will come living near this business. 2 houses down on my left, there is a dog. 2 houses down on my right, there's another dog. Across the street from us, there is a dog. They are constantly barking at each other early in the morning and late at night. I've had dogs in the past. I'm a dog lover. We've been living there for 26 years. I don't want this business to interfere with our lifestyle. The petitioner has only been living there for 6 years. We work hard to maintain our property, and I don't want that to change. This is a residential area, and the houses are so close to each other. Please deny the request. My yard is much bigger than the petitioner's yard, and that it's not enough to have this kind of business. Please vote no. Thank you.
Thank you. Is there anyone else that wants to speak in opposition? We have received communication from 161 North Quincy Street. We are in the residence of 167 North Quincy Street, next door to 161. We have lived at this address since 1969. It has never been a business zone in all those years, and I would like to stay that way. Our house is very close, and with the windows open, you can hear dogs very easily. This is not the right location for their intentions. So that was a letter of opposition from 167 North Quincy Street. Anyone else want to speak in opposition? Seeing none, and close that portion of the hearing. Is there any elected official who wants to be heard on the issue? Seeing none, and close that portion of the hearing. That concludes the public discussion portion of the hearing. Board members.
I think it's a tough request. I just, knowing myself how it is with, you know, an existing environment with dogs, not saying the business is a bad idea and that she doesn't, you know, love the business. I certainly understand that too. I do think that, you know, as a city, we should start putting it in the right zones. And that's what we're here for. That's my opinion.
I went up and looked at the site. The houses up there are very close. They are very narrow lots. My concern was that if someone was going to drop off a dog or a number of dogs in the morning and maybe pick those dogs up in the afternoon, when they pull into the driveway, they're going to have to back out onto North Quincy Street. North Quincy Street is a very busy street, both morning and afternoon, and North Quincy Street is posted no parking on the street on both sides of North Quincy Street. So the only area anybody could park is in that driveway. I don't know that if the petitioner has a car that would be parked in the driveway, which would take up a space. I have serious concerns that we have looked at these before in other residential neighborhoods, and we have expressed similar concerns. I'm sure the petitioner has all the right intentions, but sometimes what they propose to do in a strictly residential neighborhood has a negative impact on the direct neighbors that are in that neighborhood. So I think our job is to kind of look at what negative impacts, if there would be any, on not only the neighborhood, the direct neighbors, but the traffic. There is virtually no off-street parking other than a driveway. So that's my concerns.
Motion to grant.
I'll second.
Motion has been made and seconded to grant. Would the clerk please call the roll?
Mr. Lanus.
No.
Mr. Spinola.
No.
Mr. Sweeney.
No.
Ms. Hodges.
No.
Chair Galligan.
No.
Mr. Chair, that's 0 in the affirmative, 5 in the negative.
The vote is no. Positive votes, 5 in the negative. The petition is denied. The next petition is 22-74, the petitioner Christian Bugbee, 17 Conant Drive, Brockton, Mass., for a variance from section 27.9 to construct an addition to a pre-existing structure in an R1B zone located at 17 Conant Drive. Please introduce yourself.
Good evening, Mr. Chairman and members of the board. My name is Christian Bugbee, and I am the owner of 17 Conant Drive. I grew up here in Brockton, and yeah, I love my neighborhood, and I'm looking to stay here in Brockton, so my proposal here is to put an addition on the right side of my home. I'm here tonight requesting that variance from section 27.9 in reference to the front yard setback. I'm seeking relief to construct the proposed addition in my application, which would include a garage, a dining room, and an office above. The dining room and the office will be above the garage. The addition would be attached to the right front corner of the house, extend out 14 feet, and then go back the width of the existing structure. My hardship is the location of the foundation and the pre-existing structure, which was built in the mid-1970s. I am unable to move this structure, and putting the addition anywhere elsewhere on the property would disrupt its design, purpose, and functionality. I don't believe proposed project would have any negative impact on the neighborhood, the neighbors, or the current landscape. And I've also included, I've talked with all my neighbors in the area. It's a small cul-de-sac. They've opted to write a few letters, which I've also included in my application here. And I think this addition would give me the space and accommodate my growing family that I need to remain here in the city. That's all I have.
So when this house was built, if you look at the 30-foot setback, somehow this house was constructed within that 30-foot setback.
Yes, sir.
It appears as though this addition he wants to put on, he's got a tiny corner of this addition that would be in violation of the setback. And I'll tell you, some bank examiner would pick up on that. Why do you see it?
It seems very minimal as far as request for relief in exchange for aesthetic value in the neighborhood, so.
I agree. So you're looking at 32 inches, right? That's,
Yeah, it's about 31 inches, 32 inches. Right now, that front corner is 27.4 feet away from the road. So it would not be encroaching towards the neighbor. I'll actually have 22 feet from the property line to my right. The only impact here is to the street itself. Yeah. So, and the way the shape of my current property, as the building would extend out, so what would be the proposed final corner of the house, it's actually within the setback. It's actually at 31.5 feet, I believe it was.
So we understand that this addition is going to be for a bedroom and a garage underneath. It's not going to be an in-law apartment.
Nope, it's going to be a second garage underneath with a dining room, extending my dining room and an office. Yes, I have two girls who actually have encroached into my living space, and I need a little space to continue studying.
Very good. Does the board have any further questions? No further questions. Good, I'll close that. Is there anyone here that wants to speak in favor? Seeing none, I'm going to close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'm going to close that portion of the hearing. Is there any elected official here that wants to be heard on the issue? Seeing none, I'm going to close that portion of the hearing. That concludes the public discussion portion of the hearing. Board members?
I think it's pretty clear cut.
Yeah. That's not asking, I don't think it's asking for too much. I think it's minimum impact, if anything.
Motion to grant.
second?
Motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lannis?
Yes.
Mr. Spinola?
Yes.
Mr. Sweeney?
Yes.
Ms. Hodges?
Yes.
Chair Callaghan?
Yes.
5 in the affirmative, Mr. Chair, 0 in the negative.
The vote is 5 in the affirmative, none in the negative. The petition is granted. Good luck.
Thank you, Mr. Chairman. Thank you, board members.
The next petition, 2275, the petition of Tri Lee, Laurel Lane, Somersworth, New Hampshire, for a variance to allow permission to put a roof sign on the building at C2 zone located at 708 Belmont Street.
Good evening.
Good evening.
Yes, so my name is Trey, and I'm here today to petition about the restaurant side that already on the restaurant. So we took over the restaurant in June, and apparently the previous owner and many owner before that has this sign on the building, which is already, I guess, grandfathered in. So we have the sign made out to us. The sign is a simple thing. It's just a piece of I guess, laminate piece of paper that's, right on top of the building. And I guess, that sign been there forever. All we did is just, to change the name, basically it. And I'm hoping that, the council can allow the sign to be on there since it has been there for a long time. We haven't done anything to the sign except for just the letter changes. Yeah. And, I think the sign is a crucial point for us because, there's no other place that, we could think of to put the sign on the building that's visible, and plus it's been there for a long time, council.
Mr. Chair, if I may, so do you know the history of that building?
No, I don't. I'm not.
It's turned over quite a bit.
Oh, really?
Yeah, people have tried, and it's turned over, and it's turned over, and, maybe it's a lack of development at the time, and that's, certainly not your fault. I was just wondering if you knew.
Okay.
People have struggled in that location specifically,
Yeah.
and I think it's because of the uptick in Belmont's traffic and then trying to get in and out of that location. I know that's not the request you've submitted today, but I just kind of wanted to ask you since you're before us.
No, I don't know that, but thank you. Yep.
Okay.
I appreciate it.
All right. Did you choose the color on the building?
Yes, I chose the color on the building. Yep.
Okay.
I thought the other color has been there, it's old, and I just want to, change it up so it's make it new and something, something fresh, basically.
Okay. Can you just outline once again the difference between what's existing and what you're requesting?
For the sign?
For the sign.
So we just, it's basically the same thing. We haven't done anything structurally changes to the sign. Basically, nothing has changed structurally. Just the name of the restaurant, I don't know what type of material the sign guy used really, but it's just, to me, it just, I guess, just some sort of like a decal, maybe, a decal sign with letter changes. And, beside that, we haven't done anything structurally to the structure of the sign.
So the last owner had the sign up,
Yes.
and you just want to maintain that same sign
Yes.
with new?
As I understand that, there has been some sort of changes to what do you call it, the variance. I don't know what to call
Right.
it.
Yeah, I believe you're correct in that the school had to actually set their sign back and come before us also.
Yeah. So the sign been there for I don't know how long already until we took over the place, and we also checked with the sign guy to see if but he wasn't aware of anything. But it's been there. It's been there for I don't know. I guess I don't know how long that structure been there. And I'm hoping the council will allow it to stay because, we haven't really done anything to it.
So you're not planning on moving it or raising it up any
No,
higher?
we're not doing anything anything structurally to it. Yep, nothing at all. Yep.
Okay.
Do you know how far that is off the street now that the road has been worked on?
So it's you mean the sign, how far up the street?
How far from the
Or
pavement
how far
of
from the street? So it's basically right on top of the building, you call that building, on top, on right,
I think
so
we're talking two different signs here. You're talking a freestanding sign.
Freestanding sign that's closest to the street,
Also,
how
the
far away?
freestanding sign, I have no idea.
You had to estimate.
If I were to guess, huh? No,
It needs to be 10 feet back from the backside of the sidewalk. When I went up and looked at that, it appears as though the freestanding sign was okay.
Yeah.
It appeared to be more than 10 feet back from the front property line. The sign in question is the sign that's up on the top of the building.
Yeah, the top of the building. Yep, it's right on top of, and I know I also asked, who did I speak to? I think I speak to one of the city gentlemen here, and he said that one of the restaurant also has the same issue problem, but he was, he went to the council, and then, council was able to, let the sign remain where it is. I understand that there has been some changes in the zoning, but we haven't done anything, and I'm hoping you guys would let the sign stay.
Right, so the reason you're here is that you realize that in section 2769, it specifically says roof signs are not allowed.
Yes, yep.
And you need a variance in order to put that sign on the roof. To get a variance, you need to show this board that you have a hardship that's unique to that building that requires that sign to be on the top of the building. At this point, you haven't shown us any hardship other than to say that when you purchased the building, apparently the sign was up there.
Yes, the sign has been there, sir.
Okay, so years ago, that was a Friendly's restaurant, Friendly's Ice Cream. And their sign was a freestanding sign, which is the current freestanding sign that's out in front of the building.
Yeah.
So over the years, they changed the facade of that building and the face of the sign. So in August 9th, ironically, 2016, we granted a permit for an Asian restaurant to go into that restaurant. They asked for an Asian restaurant and also to sell alcohol. We did not approve the alcohol specifically because that is at the License Commission. So that was in August of 2016. The building apparently was sold, and in October 8th of 2019, the building had become vacant, and they came back before us to reopen it as a Caribbean restaurant located at 708 Belmont Street. We granted them unanimously the ability to open that. However, the understanding was the petitioner also was instructed and agreed to remove the unpermitted roof sign currently at the site. So it appears that the previous occupancy that went in there in August of 2016 put that sign on the roof.
Mm-hmm.
When they went out of business and left, they never took that sign down off the roof.
Yeah.
Okay? Now, this restaurant comes in 2019 to open up a Caribbean restaurant, and we allowed that, but specifically said whoever put that sign on the roof has to take it down. We did not grant them the ability to put that sign on the roof. Well, lo and behold, the Caribbean restaurant failed. They took off and left the sign on the roof.
Yeah.
So they have been ordered to take that sign off the roof. The prior one never did. The second one never did.
Yes, sir.
So that sign is not grandfathered in any shape or fashion.
Yes, sir.
It's an illegal sign that's on the roof, and that's why you are here today.
Yes, sir.
Okay,
Yep.
so we all understand the history of how that sign got there.
Thank you, sir.
Board, any other questions?
I mean, would you be opposed to removing the sign? Like, is there any way that you could advertise your business without that roof sign? Like,
So the sign is to anyone that you're not gonna be running that place. You know, it's a crucial point. You know, where it's, the visibility is better for all the ongoing traffic, and and we really haven't done much. We understand that the sign needs to go down, but you know, we you know.
All right, I just want to chime in on your question. If that roof sign was removed, he has the ability to take that exact same sign and mount it above the gutter line so that the top of the sign doesn't go higher than the peak of the roof. So if he wanted to use that sign for advertising, as long as the roof is behind it and it's between the peak and the gutter in that area, he'd be fine. We just need to be very careful about allowing roof signs simply because once we get a foot in the door here, we're going to see these roof signs all over the city. And right now, we have been very consistent on roof signs. So at this point, I haven't heard a hardship from the petitioner, but if the sign is critical to the business, the sign can still be used, but just relocated off of the ridge pole of the building. That's an option. All right, any other questions? Board's good?
So,
all right, is there anyone here that
yes, I would like to add something. You know,
Go ahead,
there
I'm
is
sorry.
also another, you call that a spiral sort of a thing, you know, right above, you know where the roof line is. I guess it's just maybe a chimney or some sort of a thing that, you know, it doesn't look like a chimney to me. It's like, what do you call that? cathedral-looking thing that, you know, is higher than the sign. So the sign is basically right now on top of the house. It's a big sign. You know, it will probably cost, you know, quite a big chunk to have it removed. And also, you know, we went, you know, you know, this is our fault, but we also went ahead and, you know, get the sign, get the letter replaced, basically. And, you know, you know, if it's, you know, I know that, you know, there has been a new regulation for where to put the sign, but I'm hoping, you know, you guys can take this into consideration. You know, our lease started back in June. So we didn't, when we signed for the place, we didn't get any free rent. So we've been paying rent since June 1st, you know, and the sign also preventing us from, you know, opening the salon, and I hope you guys can, you know, the council can take this into consideration and, you know, allow the sign to stay, you know, where it has been, and, you know, and I would appreciate that very much.
We're good. All done?
Yes.
Okay,
Thank you.
thank you. Board members, any other questions? We good? All right, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor? Seeing none, I'm going to close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'm going to close that portion of the hearing. Is there any elected official who wants to be heard on the issue? Seeing none, I'm going to close that portion of the hearing. That concludes the public discussion portion of the hearing. I'm now going to open it up to the board members.
I think this business needs all the help it can get, to be honest with you, the way I opened it up.
I didn't hear what you said.
I think this location needs all the help it can get. As I've explained, and he didn't know, it's turned over so often. The location has not had success. However, as a member of planning, I know that other businesses are coming. Yep. You're going to have Kentucky Fried Chicken next door, and other businesses will help your business. I want it to succeed, and I think everybody else does too. I'd hate to, you know, hit you with having to spend more money to remove it. In my opinion, in that location, the hardship is the location itself. It's where that is in relationship to where the traffic is. Yep. That's just my opinion and why it struggled. I wish you luck, but that's my opinion.
And now the issue is that this sign was never permitted, right?
No, it was ordered to be removed.
Yeah, I was gonna make one point that, like Chairman Gallagher said, that if we open the door and allow one roof sign, then it's gonna be all these other businesses coming in wanting a roof sign as well, so.
Some of them are beautiful, sorry.
As I understand, you know, can I?
I'm sorry, we're done.
I'm sorry.
Just for the edification of the board, these have come before us in the last 29 years, and I think we have denied every one of them that has ever come before us. And my concern is that if we open the floodgates on this, we are going to see roof signs popping up all over the city. And it's going to look like other communities in this state that are just loaded with signs. He says that it's a cost involved in moving that sign. However, the sign was ordered to be removed. It should not be there. Whoever negotiated the sale of this building should have known that there was a determination made by the Zoning Board of Appeals that that sign had to be removed. So somebody was remiss in not picking up on that. That same sign would be legal if it was above the gutter line and below the ridgepole. It's a determination of the building inspector as to what sign is legal. Based upon his decision, it ends up in the zoning board's decision. So what's happened here is the building inspector has determined that that is an illegal sign, and the petitioner is now coming before us asking to keep the sign. At this point, I have not heard a hardship as to why he needs to keep that sign, other than a board member mentioning the location, which is true. But I'll be very honest with you, as one member of this board, I am very, very concerned that once we open up the floodgates for these roof signs, I don't know how the genie will be out of the bottle. So just keep that in mind, that there was a reason why, when they put zoning together, they did not want these roof signs. Now, I'm not sure that if we allow this roof sign to stay there, the roof sign that we see there right now could be replaced with a like sign that could be a lighted sign. It could become a sign that is of an ethnic background that may show ethnic food. So what we're looking at there right now is a sign, a simple sign, and we're looking at that sign for what it is right now. My concern is if we allow him to keep the roof sign and he wants to change the font of the sign or make it say something else, I don't see how we can control that because it's still a sign on the roof. So I would just caution the board to be very careful in determining how you're going to vote on this, that there will be other signs, there has been signs in the past. Just be very considerate of what may be coming in the future, what has been in the past. And the reason why the city did not want signs on the roof. Now, I believe, and the building inspector may be able to help me on this thing, that the top of the sign cannot be so many feet above the grade.
There is, I'm remiss at the exact height, but there is a limit.
Yeah, so there's a number where the sign cannot exceed a certain height, all right? So suppose this roof sign that we're looking at right now is only 2 feet wide, but he has the flexibility to go another 3 feet in height based upon the distance from the ground to the top of that sign. He could actually replace that sign with a sign that is much bigger than what's there right now. So these are the things that I am just concerned about. And just, I want you to consider that when you take your vote.
Mr. Chairman, I have just one question. Are you leasing the building or?
We lease the building, yeah. The building belong to...
Yeah, so shouldn't the property owner be responsible for moving the sign?
You know, the lease was as simple as it gets. You know, there's a couple pages to the lease, and you know, he's yeah.
I mean, that's probably a conversation you should have with the property owner. I know it's probably gonna be a hard conversation, but.
Yeah, I'm not sure about having this conversation with with them actually.
All right, let's keep the discussion pretty much to ourselves. The other thing I would consider also is a logo on the roof ridgepole could be considered a sign. So when you look at the sign that's there now, if that sign was removed and some type of a logo was put up there, that logo could conform to the sign that's up there now. It wouldn't look anything like the sign that's up there, but it could be a logo on the roof that would be permitted because we permitted a sign on the roof, and the determination could be that this logo would be a sign. So this has the potential to kind of go all over the place. So that's my opinion. I'm part of the deliberation here, so. I don't want to influence your vote, but I just think these are the things that we need to consider. We had one up on West Chestnut Street, Lynch's Towing, that the board approved, but we were very specific that they could not put a roof sign on that building.
We have permission to speak, please.
I'll grant you a minute. This
Yes.
portion of the hearing is closed, but
Okay.
I'll grant you a second. Go ahead.
Yes, so we already, the chairman say, you know, we actually already have the sign, the name of our restaurant up there already, you know, made, and, you know, it's already up there, and, you know, we don't see any, we don't foresee any changes in the future, any near future about, you know, any logo or any slogan or anything like that.
My point, just to interject here, my point is you are requesting a variance, and that would be a use variance to allow that sign to go up there. So if you sold the building to somebody else, that variance for that sign would go to the next person that comes along.
Yep.
So you can stand here and tell us that you're going to have a very conservative sign that's only going to do certain things.
Yes.
But you could sell that building and the next occupant go in there and pretty much do whatever he wants to do with that sign. That's what we have to consider as a board.
Yes, sir.
Well, the chair would entertain a motion.
Motion to grant.
Second?
Motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lanus?
No.
Mr. Spinola?
No.
Mr. Sweeney?
No.
Ms. Hodges?
No.
Chair Galligan?
No.
Mr. Chair, that's 0 in the affirmative, 5 in the negative.
The vote is 0 in the affirmative, 5 in the negative. The petition is denied.
Thank you so much.
Right, good
Thank
luck.
you. Thank you.
All right, the last petition of the evening, 2276. The petition of Dep Singh, 3 Cal's Way, Mansfield, Mass. For a special permit from Article 9, Section 2729, subsection 3A, seeking permission to allow his current beer and wine store to obtain a full liquor license in a C2 zone located at 464 East Ashland Street.
Good evening, Mr. Chairman. Attorney Jake Creedon, 71 Legion Parkway, Brockton. With me is Dep Singh. And unusually, I hope I can be very concise and obviously clear. These are, some of these petitions you've had the last couple of months are as a result of an increase in liquor licenses, full liquor licenses in Brockton. Mr. Singh has had 19 years, less than that, with a beer and wine license there. So this zoning board and building department has realized that that was a good location, apparently, for alcohol. I can tell you that we're looking, because of the zoning and stuff, for a special permit. Very quickly, special permits need good ingress and egress. Obviously, their convenience store, which already has beer and wine, has been and is a good location to do that. Obviously, also, it goes all about location, ultimately, if this board approves and we get to the License Commission. I can tell you that, and I would offer to the building inspector, to the chairman, a petition in the area signed by people in the location, most of whom live in the direct area, most of whom. And I would ask.
Accept that.
Thank you. He has been there for 19 years, just almost 19 years, without any violation or any problem. He is committed to Brockton. He pays the taxes and all the other situation. And myself, not unfamiliar with what's happening at the License Commission, you really need a location that has space and a whole bunch of other things. I personally think he has the space available. He has 25 plus parking spaces, which haven't caused a problem. And so it's not, I don't want to say it's a no-brainer, but for this board, it is a location already with alcohol. I think the board should grant the situation with his track record, with his commitment to the city of Brockton, and the fact that in my investigation, the nearest full liquor would be way down the old independent liquor at the intersection of Cary and North Cary and...
Cary and East Ashland.
Thank you. So that's basically it. Again, he's committed to Brockton, has been here. We still have to, if this is approved, we have to go to the License Commission to see if one of the still available licenses fits the location and the space requirements they're now looking at.
Board members, any questions?
You said there was no violations in the past 19 years?
Nope.
Zero.
No violations?
No.
How many years' experience have you had in this business?
Well, almost 19 years.
19 years?
Yep.
I might have missed that if you said that.
Oh, yeah, I said that, yeah. Close to 19 years. I have the same problem, Mr.
Well,
Chairman.
let's call it 18 plus, so.
And that is, and, you know, it's a perimeter of the city, which the License Commission must, because it's a public need statute, is that a good location for people that need to get alcohol, full alcohol? And, you know, again, the nearest one that I could see, I did the whole area, you know, the entire, probably half of the city, and the nearest one is the Independent Liquors, which is down where Tommy Doyle's is. So this is way up on East Ashland. There's a whole population up there in Ward 6 that would be a good need. And you'll see the petition there.
I think everybody in Ward 6 signed that petition. I think everybody in Ward 6 signed the petition.
I don't know, I was a Ward 5 guy.
So our determination tonight on this whole issue is only to determine if this is an appropriate location for what he wants to do. If we approve this tonight, then they have to go to the License Commission.
Correct.
So even though we may approve this as an okay location for a liquor store, they could go to the License Commission and be denied.
Correct.
So this is just one step in the process.
That's correct.
Board members, any questions? Everybody's good? Okay. Is there anyone here that wants to speak in favor?
Hopefully it's a neighbor.
Yeah, he is.
Oh, is it? You gotta give your name.
If you don't know me, I'm Skip Gerald Graziano, and I live around the corner from the shortstop, whatever you want to call it. And me and my wife couldn't make it here tonight, but I'm here representing her too. And I live at 14 Colgate Road around the corner, and every time I go in the store, it's always nice, neat, and everything in there, everything's in place. And outside, it's all clean. In the wintertime, you don't have to shovel your way to get in there. And one final word, the house that I had, Chief, is my cousin, Jim Young, that worked for you as a lieutenant.
I know the house.
And I hope he gets a license. Thank you.
So you're speaking in favor, correct?
Yes.
Is there anyone else that wants to speak in favor? Seeing none, I'm going to close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'm going to close that portion of the hearing. Is there any public official that wants to be heard on the issue? Seeing none, I'm going to close that portion of the hearing. That concludes the public discussion portion of this hearing. I will now open it up to the board. Board members.
Since this has been in operation for 19 years with no violations, I don't see an issue with this.
I feel the same way. If you can take trips out of other areas and keep it within your own neighborhood, he's been selling alcohol for 19 years. He's got an ID, he's got to go through that process, the whole licensing process. But to kind of keep a trip more localized, I think is actually beneficial.
That's a good point. Thanks for flagging that. I didn't even think about that, but yeah, it makes sense.
I'll make a motion to grant.
Second.
Motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lannis?
Yes.
Mr. Spinola?
Yes.
Mr. Sweeney?
Yes.
Ms. Hodges?
Yes.
Chair Galligan?
Yes.
Mr. Chair, that's 5 in the affirmative, 0 in the negative.
Vote is 5 in the affirmative, none in the negative. The petition is granted.
Thank you, member.
Thank you. Good luck. All right, that is the final case for this evening. Originally, we had considered taking a vote tonight on electing our chair and vice chair of this board for the coming year. And the fire chief is not here tonight, and in all fairness, I'd like to have him participate in the vote. So I'm going to postpone taking a vote until the September meeting. Everybody good with that?
Good.
Yes. Sounds good.
So get your candidate lined up. Do your politicking. And This concludes the meeting.
Motion
of
to
the zoning
adjourn?
board.